Order the State of Rhode Island Coastal Resources Management Council semi-monthly meeting to order. Today is Tuesday, November 25, 2025. I would ask that the record reflect the council members that are present as well as CRMC staff members that are here as well. First matter on the agenda will be approval of the minutes of the previous meeting, that meeting being October 28, 2025. I would entertain a motion to approve them or any changes, corrections that someone may have if that's the case.
Motion.
The motion has been made by Mr. Rossellino. Is there a second?
Second.
Second by Ms. Reynolds. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? Motion carries. Subcommittee reports. Director Willis.
Yes, thank you, Mr. Chair. The Rights of Way Subcommittee met earlier today to hear the legal counsel recommendation on the Buttonwoods, what we call the Buttonwoods matter. And that recommendation was discussed amongst the subcommittee members with the parties pro and against present, where a decision was made by the subcommittee to have the two parties respond to the recommendation of legal counsel in this report by January 16th, end of the business day on that day. And also at a future time, the subcommittee will, based on the material in the record, will hold a hearing in the city of Warwick on public use of the Buttonwoods matter. So that was done at an earlier meeting of the Rights of Way Subcommittee today. And then lastly, the Rights of Way Subcommittee meeting on the Spring Avenue extension matter. The next evidentiary hearing is scheduled for January 6th in the town of Westerly at the Senior Center.
Okay. Any questions of Mr. Willis from the council? Thank you. Staff reports.
Thank you, Mr. Chair. Just a couple of staff reports, staff matters in my report. I've mentioned this before. The Point Street Bridge, which is an old railroad trestle bridge that has hundreds of creosote pilings, the CRMC, through our staff, and Bruce was very instrumental in getting a NOAA award to have those creosote pilings removed. Staff met with the NOAA folks, the award source, to kick off the meetings and the actual work involved to get that project going. So we have project partners with the Nature Conservancy and the city of Providence. We will begin working with the Nature Conservancy on actual construction issues to remove those pilings and have them removed and disposed of properly. But I want to thank Bruce for all his hard work and staff that also worked on that to get the agency the millions of dollars to have that project be done. So hopefully by this time next year, we'll be able to have a much nicer looking Providence River inside the hurricane barrier because of the removal of those. Lastly, you're probably, since last time we met, you're probably aware through reading in the Journal and the Globe and other publications, the South Coast Wind project, which this council approved through federal consistency of the offshore project, the cable as it goes through one of our or two of our GLDs, was awarded the ability to enter into power purchase agreements with both the state of Rhode Island and the state of Massachusetts last August. Those contract negotiations between those parties have been ongoing since then, except Rhode Island Energy has pulled out of those negotiations with South Coast formally. So right now, the only negotiations that are ongoing are with Massachusetts. That we will still look at the cable as it comes up the Sakonnet River. We have an active application. We will still move forward on that. But I wanted to let you know that that particular part of the Rhode Island equation has been reduced by Rhode Island Energy being pulled out of that. So that's what I have there.
What's their reason for that? Is it price?
The Rhode Island Energy
price, or
I've asked that question of a couple of different folks, and I don't have an answer as to why. I assume they just could not find an agreement on what that price would be, but I don't know that.
Mr. Chair?
Yes.
Just have a couple of questions. Mr. Willis, are we still required to continue our review of the energy projects in light of Rhode Island Energy pulling out of the
PPA negotiations?
Right, yeah, that's a good question, actually. So as I mentioned, through the federal consistency process last year, actually in 23, I believe, we approved the offshore wind project's export cable that eventually will come up the Sakonnet River. And that application was formally accepted by us last August, and we've been reviewing that application since then. Now we learn Rhode Island Energy has pulled out, but Massachusetts has not. So that cable, while it comes through Rhode Island waters, it'll also go through the town of Portsmouth and up Mount Hope Bay and then back into Massachusetts waters, still has benefits to the state of Rhode Island, secondary, maybe even tertiary, but they're benefits that you can argue are still there for Rhode Island, in particular, infrastructure improvements on Aquidneck Island as it goes through the town of Portsmouth. And then eventually, on the assumption that it gets built out and Massachusetts has an agreement with it, that the power being delivered by the project would go to ISO New England, where Rhode Island purchases its power from. So technically, there is still the benefits to the state of Rhode Island. So we are therefore keeping our review ongoing.
Do you know if there's been any discussions between the developers and the Fishermen's Advisory Board regarding agreed compensation?
So, okay, so, the compensation matter for any particular project, but in particular, renewable energy in the offshore environment, if mitigation can't be done successfully, meaning 100% mitigate the project for the impacts that are occurring from the project, there has to be compensation. That's what our Ocean Special Area Management Plan requires. In this case, there will be a compensation component that is part of our review. The problem with that, and if you remember and forgive me, I got to go back a little bit. When we were looking at several offshore projects, we had 4 in the calendar year 2023. A couple Ørsted projects, we had South Coast, we had New England Wind, and the FAB, the Fishermen's Advisory Board, where we get the compensation agreement in front of to help us understand what those compensations should be, resigned because they're just overwhelmed and we weren't getting, they in their minds, they weren't getting the compensation they felt they deserved. It took us a full year to get a new FAB reconstituted. And in doing so, we also try to get legal counsel to help the FAB understand what some of the compensation negotiations should be relative to a compensation offer that's given by the developer, which has been given by the developer in this case. So we are trying to figure out what those negotiations should be, get the FAB an attorney. They wanted the previous attorney, if you remember, it was Attorney Desitel, that South Coast absolutely refused not to be part of the negotiations because, without going into a lot of detail, Attorney Desitel's firm was instrumental in the Trump administration pulling back South Coast Winds and one of Ørsted's projects to get additional federal review. It actually stopped the Revolution project for a month or so. So staff agreed that it would not be an appropriate representation for the FAB. So Attorney Desitel offered a couple other names that we contacted. I spoke to a couple weeks ago. They were interested. As of yesterday afternoon, one of those attorneys said, I'll get you a proposal on what I would have to charge and whatnot. And then literally before I got in the car to come up here, those 2 attorneys backed out. So I don't have legal representation for the FAB on that. We're still working on getting that in the context of keeping our review ongoing. So a little complicated, but appreciate it.
Where's the staff in their review?
We have, sure. Our staff report is, I'll say 90% done. And we've reviewed it amongst ourselves. We meet with South Coast Wind every 2 weeks. We met with them this afternoon and explained to them some of the positions we have. We have conditions that we put on that we will be recommending to you all that we put on through our staff report that we explained to them. So we're very far along in our review in hopes that we can get this compensation figured out and get it up to you in January. Really my goal.
Those are the questions.
All right, any other questions of Director Willis? All right, bring us to our formal agenda. Rights of Way Subcommittee recommendation before the council for review and action. That's file number 2023-03-069. Town of Westerly. Proposed CRMC rights of way designation of Everett Avenue in the Watch Hill section of Westerly. I will turn it over to Attorney DeSisto at this point to provide a posture of the case and an update.
You have a report and recommendation that we drafted regarding Everett Avenue in Westerly. This is a petition actually by the town of Westerly to dedicate Everett Avenue, and there's a description in the report as a right of way to the tidal waters of the state of Rhode Island. And there's a very long history involved in this matter. The right of way subcommittee originally met on October 25th, 1978, November 30th, 1978, and January 4th, 1979 in the town of Westerly for public hearings. And along with the Westerly Town Council, they also had a meeting with the Westerly Town Council on December 3rd, 1979. And those public hearings were held. There were other rights of way in Westerly that were considered at that time. Then in January, January 30th, 1980, the full council voted to designate Everett Avenue as a right of way to the shore. Whatever the reason, that was put on hold. The council took some subsequent action. I wasn't quite able to determine from the records that we have exactly what happened and why. But this Everett Avenue proposal has been fallow for some time. It's been brought forth by the town of Westerly that it should be dedicated as a public right of way to the shore. There was a plat map that designated this. It was an 1886 plat map that was recorded in the land evidence records for Westerly, showing this right of way. It was unnamed at the time. There's references in deeds past that that were picked up by the title attorney that CRMC had at the time, John Lallo. Alan Goldman, who was legal counsel, agreed on it. The town of Westerly has made representations that this is in fact a public street. It's in the harbor management plan as a public right of way to the shore. You have your dedication and acceptance, as the rights of way subcommittee members heard in the earlier meeting this evening. You have the two elements that would indicate that this should be a public right of way. Want to give a shout out to Mr. Palazzolo. He did some research on his own that gave supporting evidence to the fact that this is a public right of way to the shore. One of the citations that he gave were several rights of way reports by the state of Rhode Island from 1958, 1970, and 1978 that list Everett Avenue as a public right of way to the shore. I should note, and again, this goes to what was said in the earlier meeting, at those public hearings back in Westerly, members of the public did state that they had used Everett Avenue as a right of way to the shore. Apparently, it's a very good fishing area. Based on all of that, based on prior actions of the CRMC, I recommend that the council now vote to adopt Everett Avenue as a public right of way to the tidal waters of the state of Rhode Island. We have the solicitor for the town of Westerly, Mr. Conley, here with us tonight on behalf of the petitioner. Assistant town solicitor Sarah O'Toole has been in previous meetings. He's here also. to speak on this, and I think it's appropriate to hear from them and anyone else that wants to say anything about Everett Avenue, including Mr. Rabideau, if he wants to speak.
All right, any questions of Tony from the council at this point, just based on his update? No? All right, sir.
Thank you, Mr. Chairman, members of the committee. William Conley, I am town solicitor for the town of Westerly. And as Mr. DeSisto has noted, the town has requested that the Everett Avenue right-of-way be formally designated as a right-of-way to the Rhode Island coastline by this council. I really don't have anything to add to what Mr. DeSisto said, that we agree with the history, we agree with the papers, and we agree with the conclusion. So I'm just asking you to accept that recommendation, and I want to thank Mrs. DeSisto, in fact, to all of your staff who picked this up from, the 1980s and are now finally finishing the task. So thank you very much. Did answer any questions you may have.
Any questions of the council of Attorney Conley at this point? Thank you.
Mr. Palazzolo has his hand up.
All right. Anyone else wish to speak on the application this evening? I'll ask you to come forward. Is this public comment or are you swearing?
No, I don't think it's necessary to swear Mr. Palazzolo in.
Okay.
Good evening, Anthony Palazzolo, North Stonington, Connecticut. I'm licensed to practice law in California and in Connecticut, but I'm not licensed to practice law in Rhode Island. I'm here just as a would-be user of Everett Avenue and other rights of ways. I don't have any clients with any interests in this matter. I can't because I'm not licensed to practice in Rhode Island. I've been doing this work for roughly 5 years now. My personal capacity, I've never taken a dime or ever asked anybody for a dime, never asked anything for myself, only for the public to be able to access the tide waters of the state. I think it's important to clarify some of the procedural history here, tease out a couple of different things that are going on. And it's because it could have a profound effect on other rights of ways that the CRMC has already looked at. In addition to the Everett Avenue right of way being considered in the 78-80 time period, there were a total of 18 rights of ways there, and 5 of which were essentially put into procedural purgatory. As with Everett Avenue, as you heard from Mr. DeSisto, all 5 of these were approved by the subcommittee in January. I believe in 1979, and they were approved by the full council in January of 1980. And then in August of 1980, they were pulled from designation and put into purgatory, in essence. Now, there's a transcript for that. I got it from the CRMC. And although Mr. DeSisto doesn't seem to believe he understands what happened, I think I know what happened because I read the transcript, and I would recommend that you do the same. There was a discussion in there that some of the participants in that right-of-way proceeding complained that they thought they were going to have another opportunity to speak, to present information to the CRMC, but that didn't happen. And so what they said was, out of an abundance of caution, we don't want to allow these to go into issuance because there might be an appealable issue there. So we want to give the participants of these particular proceedings an opportunity to provide additional information that they think might be important for these rights of ways. Now, I want to stress here, those were personal matters. Harold Solovicic represented a number of individuals, including Mary Myers and her husband. And what the CRMC did was they said, these particular people think they have something else they'd like to say. Let's hold these rights of ways in suspension, give them an opportunity to provide information. Mary Myers is long dead. Her husband is long dead. what the CRMC did not do is say, we're just gonna keep these things open for all eternity, and other successors in interest have for all eternity to come in and say, complain about issuance of these things. These were, what the CRMC did is they wanted to protect the opportunity for these particular participants to provide information. It seems to me, once all of the relevant people have died, the CRMC should have automatically stood by its prior determination that these were rights of ways and let them go to issuance right then and there. Now, that didn't happen. This arose because I and other members of the public did research and persuaded the town of Westerly to take this right of way out of purgatory and pursue it with this new information. However, it seems to me the proper ground for designation of this right of way is simply that there's no one left from the original proceeding who might come forward with information. That is to say, the original designation stands. All of the participants had every opportunity in the world to provide the information. They failed. That alone is sufficient to say this should be a right of way. There were a total of 5 rights of ways with this same procedural posture. And therefore, if you find this is the primary ground for designating the right of way, then the other 4 should follow. They would be Niantic Avenue, Water's Edge Road, Winnapaug Pond, and another one that escapes me. But the record is very clear. There's 5 of them. And these were, let's be clear, these are not proceedings that ended in a conclusion of no right of way. The council found that there were rights of ways, but then, out of an abundance of caution, gave extra opportunity to those participants. So this is a very specific procedural posture, and I would encourage you to designate this as a right of way because there's no opportunity left for providing new information. Now, in the alternative, one thing I did hear Mr. DeSisto say is that we supplemented the record with information which included a deed from the then record owner to the town of Westerly for essentially all of the rights of ways in Watch Hill. That was from 1890. So, we heard from Mr. DeSisto on the theory of an incipient dedication, and that certainly was the theory that was being advanced back in 78 and 80. But the new information that we provided not only supported that, but we found the deed from 1890. And then we found the town council minutes from 1891, which accepted the deed, which ordered that the deed be recorded in the land evidence records, and that all of the roadways, there are I think 9 of them there, were to be incorporated into the road network in the town of Westerly. How insightful does one need to be? We're talking about 135 years of outright ownership of Everett Avenue because of this deed. Now, again, that's in sort of the latter round of hearings that we've had in the last year or so. But I also believe that Mr. DeSisto is correct. The original ground was adequate. It should be supported. And the way I see it, you uphold the original actions. You find that the time period for providing additional information has expired, and you're standing by your original decision. Nonetheless, in the alternative, you found that the 1890 deed and the acceptance by the town of Westerly is also an adequate ground for designating this right of way. And if you do these things, then you're going to find quite a few other rights of ways in Westerly that should sail through the subcommittee and this council. Again, Water's Edge Road, Niantic Avenue, Winnapaug Road, and a
Meadow.
different one. And I will also mention that Everett Avenue was expressly listed in the 1890 deed that I mentioned. So it was another road called Meadow Lane in sometime in the 2000s, I believe. That was the name of that road was officially changed to Water's Edge Road, which is another proceeding that's pending before the subcommittee. And so, I mean, obviously, if you find that the deed is adequate, then that too, that's two grounds there. The other three, they are not in the deed, so it wouldn't be a belt and suspenders thing with the other rights of ways I've mentioned, but nonetheless, those were designated by the subcommittee and the full council. I thank you for your time and I answer any questions if you have any.
Any questions of Mr. Palazzolo? No, all right. Does anyone else wish to come up and speak? Okay. Turn it back to Attorney DeSisto to shed some light comments on the great history from Mr. Palazzolo. So thank you for that presentation.
Well, I have to admit, he's been very helpful. I got to give it to him. But because he's been helpful, that's why I'm recommending that you approve this right of way now, notwithstanding the fact that, and you can incorporate that into your findings, that this was done previously in 1980. And that's only because of these subsequent things that were not available to the council in 1980 that are available to you now and actually referenced in my report to the council. So I think it's a good idea to include those additional items. One thing I do agree with Mr. Palazzolo, I understand they want to give an opportunity to some people that had objected at the time, but they never did. And that was, over 40 years ago. There's been no objections. The Everett Avenue was popped up twice this year in 2025 on the right-of-way subcommittee. And on one of them, there was an attorney here for one of the abutting property owners that interposed an objection. The matter was continued to your April meeting, and that objection was withdrawn based upon the fact that those original objectors either can't, but even though they can't now, never did in the first place. I think that is further evidence, as referenced in my report, that this is and should be dedicated as a public right-of-way to the tidal waters of the state of Rhode Island.
Thank you.
So I'm going to ask you to vote as such.
Any questions of Attorney DeSisto from the council? Is the council in a posture to make a motion?
Chairman, I
Mrs.
make a motion based on the report prepared by CRMC counsel and materials in the CRMC file that the council has reviewed, and based on the discussion by members of the public and officials of the town of Westerly, I would move to dedicate Edward Avenue in Westerly as a right-of-way to tidal waters of the state of Rhode Island.
Is there a second?
A second.
Who seconded?
Ron.
Seconded by Mr. Russolino?
And Ron.
Ron? Okay, Ron as well. Also seconded by Mr. Gagnon. Any discussion? Hearing none, I will poll the council. Mr. Flynn? Mr. Izzy?
Aye.
Mr. Russolino?
Aye.
Dr. Ruder?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
I too, Raymond Coyer, vote aye. The motion is approved unanimously.
Thank you. Thank you.
Thank you. Next matter on the agenda will be council review and action on a technical amendment to previously adopted CRMC proposed rulemaking. Title of the Rule is Management Procedures. 650-RICR-10-00-1. Rulemaking Authority of Rhode Island General Laws, Chapter 46-26, and sequenced. And I think, Bruce, you have this for the council?
I do. Thank you, Mr. Chair. As you all recall, this rule change amendment was adopted by the council on October 21st this year. And you had directed staff to initiate final rulemaking and submit the final rule to the Office of OMB and SOS. Staff did that, and upon issuing it to OMB, they recommended some technical amendments to the language that we had previously adopted. And it is on the agenda. So the language we had previously adopted is from section 1.2, meetings and members. And we had, in looking at section B here, we adopted the language pursuant to 4623, or a quorum shall consist of 4 members of the council. And the proposed technical amendment language is to strike that and add the quorum of the council shall be pursuant to Rhode Island General Laws 4623-4. So although the language we adopted tracks state law, there was a little confusion as to us stating that the council quorum would be 4 members, because there will be a period of time after this becomes effective in our regulations that the quorum of the council will still be 6 members, and that's at least until March 1st, 2026, or until 7 new members or 7 members are appointed under the new council. So we feel it's a little clearer for the public, and we support the technical amendment that OMB suggested.
All right.
So, we're recommending that the council adopt it and direct us to resubmit to OMB and SOS.
Okay. Any questions of Bruce from the council? Yes, Mr. Flynn.
Does this also protect us in case they change the law again? And that we'll be in compliance with whatever they change the law to in the future, without having to cite a specific number?
Yeah, I suppose it would. I mean, we referenced that specific section of Rhode Island General
So
Law.
it would still be in that section. If it gets changed again, then the new language is part of that section. So, okay.
Okay. Is the council in a posture for a motion?
Make a motion to adopt the technical amendment as presented by the staff and direct the CRMC staff to resubmit the final rule to OMB and SOF.
Perfect. Is there a second?
I'll second.
All right, motion been made by Mr. Russolino, seconded by Mr. Flynn. Any discussion? Hearing none, I'll poll the council. Mr. Flynn?
Aye.
Mr. Izzy?
Aye.
Mr. Russolino?
Aye.
Dr. Ruder?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
I too, Raymond Coyer, vote aye.
Were you adjourned?
Yep, and Mr. Willis?
Just want one update. There's one meeting in December, and that'll be on the 9th of December. There will not be a second meeting in December. So we will have a fairly full agenda at the next meeting, but I just want to remind you, we'll only have the one meeting in December. And neither subcommittees, meaning planning and procedures nor rights of way, will not be also meeting in December. Sorry. But just the full council on December 9th.
All right, anything else to come before the council?
Motion to adjourn.
A motion has been made to adjourn. Is there a second?
Second.
All in favor, say aye. Anyone opposed? Motion carries. Happy Thanksgiving, everyone.